Hey everyone, welcome back to U.S. Immigration News, where we break down the latest in U.S. immigration news to help you stay informed and prepared. Today, we're diving into some significant updates affecting green card holders, also known as lawful permanent residents, in 2025. With the return of stricter immigration enforcement under the second Trump administration, traveling abroad as a green card holder has become more scrutinized than ever. While there aren't brand new laws rewriting the books, heightened enforcement practices and policy shifts have effectively created stricter terms for reentry after international travel. Important disclaimer: this isn't legal advice. Always consult an immigration attorney for your specific situation. We're basing this on official sources and recent reports to give you the facts without any hype or negativity. Let's break it down into 5 key rules and requirements that every green card holder should know before planning a trip. These stem from increased CBP scrutiny, especially for extended absences, criminal histories, and other factors. 1. Absences over 180 days now trigger presumption of abandonment. Get a reentry permit before leaving. If you're planning to be outside the U.S. for more than 6 months, you must apply for a reentry permit, Form I-131, before departing. Without it, CBP officers may presume you've abandoned your permanent resident status upon return, leading to secondary inspections, detention, or even deportation proceedings. This isn't entirely new, but in 2025, enforcement is ramped up at port of entry, with officers more aggressively questioning ties to the U.S. like jobs, homes, or tax filings. To meet this, file Form I-131 at least 60 days before travel. It costs $660 as of recent fee updates, and it's valid for up to 2 years. If you're already abroad and absent for over a year, you'll need a returning resident visa, SB1, from a U.S. consulate. 2. Criminal convictions. Even minor ones can block reentry and lead to immediate detention. Green card holders with any criminal record, including old or minor offenses like marijuana possession, face heightened risks during reentry. At the border, CBP can detain you and start deportation if the conviction falls on the ground of inadmissibility, e.g. drug offenses, crimes of moral turpitude like theft or assault. Unlike inside the U.S., where one minor marijuana conviction might not trigger deportation, borders treat it differently, no exceptions. In 2025 changes, social media monitoring and database checks are more intensive, flagging even diverted cases or withdrawn pleas as convictions. To comply, review your record with a lawyer before travel and carry proof of rehabilitation if applicable. 3. Political or national security ties could result in secondary screening and deportation risks. If you've been involved in political activism or have alleged connections to groups labeled as threats, e.g. certain gangs or organizations tied to national security concerns, reentry could involve extra vetting. The administration's focus on national security allows broad claims to detain or deport, even without solid evidence. Current scenario: this enforcement spike targets activities like supporting certain causes, with CBP pulling travelers into secondary inspections more frequently. To navigate, avoid discussing politics at the border, know your rights, e.g., right to a lawyer, and prepare a safety plan if you're at risk. 4. Marijuana use or possession admissions are grounds for inadmissibility at ports of entry. Even if marijuana is legal in your state, admitting to use, possession, or related activities during CBP questioning can make you inadmissible. This rule applies strictly at airports and borders, where federal law overrides state leniency. Reports show officers pressuring admissions to build cases. 2025 updates. With expanded enforcement, this has led to more detentions for green card holders returning from travel. Tip: exercise your right to remain silent on non-essential questions and consult legal help if detained. 5. Pressure to sign Form I-407. Don't abandon your status without a fight. Upon reentry, especially after long trips, CBP may detain you and urge signing Form I-407 to voluntarily abandon your green card, promising quick release. Signing means losing your status permanently. Don't do it. You have the right to contest any abandonment claim before an immigration judge. New in 2025, increased reports of this tactic under tighter policies. Always demand a hearing and contact family or a lawyer immediately if detained. What's changed in the current scenario? The big shift in 2025 comes from the second Trump administration's policies, effective after inauguration, which emphasize aggressive enforcement without major legislative overhauls. While the June 2025 travel ban targets 19 countries, full ban on 12 like Afghanistan, Iran, and Somalia, partial on 7 like Cuba and Venezuela, it explicitly exempts green card holders. However, indirect effects include family separation fears and overall uncertainty, making many hesitate to travel. Reentry after extended travel, 6 months, now faces more rigorous checks, with risks of NTAs or bond hearings. U.S.'s rules remain standard, present a valid green card and passport, but the vibe at borders is stricter. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
In 2025, the stricter U.S. immigration enforcement under the second Trump administration has made travel for green card holders more challenging. While no new law exists, tighter border checks, not field absence over 180 days is possible, abandonment without a re-entry permit. Even minor criminal records can block re-entry. The CBP expanding database and social media checks, political or national security ties trigger secondary screenings, and marijuana use legal in states but illegal fatally can cause inadmissibility. CBP officer reportedly pressured travelers to sign Form I-407 to abandon status, though the 2025 travel ban excludes green card holders. Enforcement intensity and period of detention have significantly increased.